There was an incident last October in which Miss Russell was a victim of domestic assault. Grant, our son, together, he's lived with me almost exclusively since then. The last time he saw his mother was on February 24th.
And it was almost as if he wouldn't agree to let me have Grant back unless I agreed to changing the orders. So I have not seen my child in almost 2 months because I won't agree to his new terms.
The next case, or do you need a short recess?
I'm okay, Judge. Thank you.
Okay, great. Okay, then we will go ahead and call cause number FM 23-005557, Russell versus Reed. And if the parties would just introduce themselves on the record for the court reporter, you can go ahead and both unmute now.
Hello, Your Honor. I am Tyler Reed. I am the child's father. I am the respondent in this case, but the movement on this motion.
I'm Haley Russell. I am his mother, and I am responding to this motion.
Okay. And before we proceed, I'll go ahead and swear both of you in. If you would both raise your right hand, please. Do you swear or affirm that the testimony you will give in this cause will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Yes, Your Honor.
Okay, thank you. Okay, and let me just kind of lay out the groundwork of how this proceeding will be conducted since you're both representing yourselves. You have a 2-hour announcement, and that means I will divide the time evenly. You'll both get up to an hour maximum time. You don't have to use that, but that's the most amount of time given the 2 hours. And so since Mr. Reed is the movant, he will go first. And Miss Russell, then you will go second. And then at the conclusion of the hearing, you will both be able to make a brief closing remarks after any evidence or testimony has been given. Any questions about the way the hearing is to be conducted?
Yes. Would you need an opening statement from me?
It,
I
it's
need
helpful.
repeating what I put in the motion, I guess. So it's essentially the same thing. So I don't want to waste the court's time if you have read the motion.
Okay.
Um,
Well, I think it's always helpful for the court, under the law, in order to modify, we're looking, I guess I just need you to explain the facts and circumstances that you think support what you're asking the court to do. You don't have to read the motion to me. I'm not asking you to do that. But the court reporter is here taking the record, and I'm here to listen to the testimony of both sides prior to making the decision on this. So just a couple of minutes would be fine, Mr. Reed. You may proceed.
okay. Yes. Thank you, Your Honor. Sorry. Main reason I ask is because reading from a script is the most nerve-wracking thing to me. But
Yeah, I don't want you to do that at all.
yeah, I have something typed out. I'll just follow my notes. Thank you.
Okay.
Okay. So I have submitted a motion to modify the temporary orders because I do not feel that they are the ones that are currently the current orders are in the best interest of my child. The modifications that I'm asking for are to have me named as sole managing conservator or primary joint managing conservator if the former is not granted. I'm asking that possession be modified so that the child resides primarily in my care, with Miss Russell having 1 weekend of possession per month, chosen by her, provided she gives written notice 2 weeks in advance. Or if that is not granted, we would adhere to the standard possession order, but with me designated as the primary conservator. And the third modification I'm requesting is removing any child support obligation owed by me to Ms. Russell. The current orders of it, they stand is standard possession order with Ms. Russell designated primary. We do live over 100 miles apart. So I've been getting, it's order that I get first, third, and fifth weekends. in I believe 42 days over the summer. Circumstances have changed quite substantially since then, and that is the testimony that I'll be providing, explaining that the changes that have happened. Specifically, there was an incident last October in which Ms. Russell was a victim of domestic assault. And Grant, our son, together, he's lived with me almost exclusively since then. The last time he saw his mother was on February 24th. She has made negligible effort to keep in touch with him during that period or check up on his well-being at all. I've requested multiple times to have a conversation over the phone to figure out a path ahead for us, and she has failed to call me, despite telling me that she would several times. At the conclusion of this hearing, I will ask that the court grant my motion in full. Thank you, Your Honor. I am now ready to be sworn in. Oh, I was already sworn in, sorry. I am now ready to give my testimony.
Okay. Well, I'm going to take an opening statement from Ms. Russell if she would like to make one. Ms. Russell, you can give me your response to the motion and what you are asking the court to do at the end of this hearing.
Yes, ma'am. In October, there was an incident that happened here. Thankfully, Grant was not here when that happened. Huge relief on that. After that happened, we had discussed, just out of respect for Tyler's feelings about what was going on and me wanting to protect him from anything in the short term after that had happened, from any unknown things going on while there was an EPO in place. We had discussed him staying with Ty for more time until things settled down and things got back on track with normal life. We had gone to a week on, week off thing. And then after that happened in October, he stayed with him for longer than that so that I could get things settled down here. And once things started to get back to normal, I have two older children. I have a 14-year-old daughter and an 11-year-old daughter that live with me all the time. Sorry, gather my thoughts. So then once things started settling down, I would try to get my son back, if that makes sense. He wanted to have these big conversations about permanency that I was not comfortable with to go forward. Grant is already enrolled in school here. His sisters very much miss him. Things are settled down with that court case. Everything is pretty much back to normal. And I'm just ready for things to get back to the way they're supposed to be. But it feels like he won't let me get my child back unless I agree to these new terms. And so I have agreed to have conversations with him that haven't happened because he won't come off of what he wants to go forward. So I have not seen my child in almost 2 months because I won't agree to his new terms, and therefore we have not made the exchange. I've been trying to be level-headed and not I was in the works of filing a writ of habeas corpus, and he beat me with this motion to get that in. It was all drafted. I was ready to go, and then this motion came in. So I am just kind of at a loss for what to do, because I do believe that Grant should be with me. I know he loves his dad and everything is good there too, but he has sisters here he hasn't seen. He's enrolled in school for the fall, and anything that Tyler is going to use as evidence of things is from years ago. The photos that he's going to offer as evidence today are from a time when we were moving in 2023 and that were addressed at our original temporary orders hearing. And things are different now. So I just am ready to go back to normal, get my child in school in the fall, and move forward.
Okay, thank you. All right, Mr. Russell, You may call your first witness. I presume that might be yourself, but let me know.
I'm Mr. Reed. She's Miss Russell.
I'm
Sorry, both
sorry.
our last names. Okay, yes. Yes, I
It's
call myself.
Friday. It's been a week. Mr. Reed, you can just testify in the narrative. So, in other words, tell me whatever you want me to know about the situation. And when you're done, you'll pass yourself as a witness. And then at that point, Ms. Russell will be able to ask you questions about your testimony.
Sure. Thank you, Your Honor. I've prepared a calendar to kind of show how things have gone over time. If it will be of assistance, it's what did I mark it? Exhibit number 1, I believe. Yes, exhibit number 1. I can display it if you'd like to see it, and if you don't think that it will be of any use, then
That's fine. You may share your screen to show it.
let me pull it up here. Sorry, once again, let me get this prepared real quick. Where did I put this? Okay. Oh, I'm sorry. The opening system settings. One moment. It didn't let me set this up on the test. So. Oh no. Okay. I'm so sorry. I apologize, Your Honor. Can I rejoin the call really quick? It's forcing me to quit and reopen in order to share.
Okay, that's fine.
I'm sorry about that. Yeah, one moment. Wait. Oh, maybe not. Never. Oh, my apologies. No, it was. It would allow me to do that. Okay. Are you able to see my screen?
Yes, I can.
Okay. All right. So exhibit 1. All right. What I have here in this exhibit is calendar that I set up of everything that's happened since our temporary orders hearing was on October 23rd, 2023. So I've done everything since then. Just to give as quick a recap as possible, there were a lot of events that have happened, and I don't want to waste time like just kind of feeling like I'm nitpicking everything going through this. But we started out with the SPO and agreed to our own modification of it pretty much right out the gate, where I would get where exchange days would be on Thursdays instead of Fridays. And for the most part, we followed that throughout all of 2024. And then beginning in 2025, we switched to a 50-50 agreement where it was week on, week off exchanges on Sundays. That's really where things get more relevant. But also, for more context here, I've included, because I'm an Excel nerd, I've just parental splits. The one here is days solely with the grant was solely with each of us. That means not exchange days, and then overall is exchange days included. So we have me, Haley, and then shared here, and you know, it'll just show over time that possession has actually swung over to me, where he's spent most of his time with me. So I will skip through most of this. So let me see where it gets relevant there. So one of the issues, and I'm going to have to kind of glaze over these because I didn't submit text message things and stuff like that. But there were several delayed exchanges that she gave last minute notice on. Not last minute, but day of notice. We'd be meeting on a Sunday, and she would text early in the morning that she couldn't meet for various reasons. But because I don't have those provided, I'm just going to call that out, but not mention every specific one. However, here in June, this was my summer time, and the way I requested it was I would have these first 2 weeks, and then she would have this week. Now, so there was supposed to be an exchange on the 16th. She was not able to make that one. So we met on this day instead. And then I agreed to let her have Friday, so my son got more time because he had spent quite a while away from her. However, I was only supposed to get this weekend of the 21st through the 23rd. And then she reported on the 23rd that she had car issues. And so she couldn't make the exchange on the 23rd. And at that point, I'm like, okay, keep me posted. I believe I asked her on the 24th when to expect her. And at a certain point, she went essentially silent. And granted, I just kind of wrote out the week and I just told him I'm not sure where she is. And so this is why there's such a huge block of my time in July here. June and July. And so the rest of this it was just kind of as scheduled with my summer possession time. And then we resumed the SPO. Around August or September, I cannot remember the exact date because it was something my son told me, but let's see how I'm doing this because it's hearsay. Well, okay, I'm offering this as an explanation for my reactions, I guess, at the time. But I cannot prove that my son said this to me because I didn't record him. But he told me that he had been camping with Miss Russell's ex, the father of her two daughters. For a bit of context on this, just shooting back in time really quick, she was with this man, his name is Jeff. Prior to our relationship together, she had historically described him as abusive. She had told me that he had physically abused her before. She had told me that he was not good for the children and had very little good to say about him. And had heard this over the span of years. So it was very concerning when I heard that this was going on. Then somewhere around here in September, he started telling me that that's where he had been staying, was at Jeff's house, which is the house that Miss Russell is currently in, I believe. And I asked him if he had been living there, and he said yes. And I then asked Miss Russell about it, and she told me no, that they had stayed, I don't know, 1 or 2 nights. I cannot remember exactly, but she denied it. Despite that, each time I would see Grant, I would ask him where he stayed, and he would say he was at Jeff's house until eventually, I can't remember because I don't have these stored in text, but like eventually came to find out, she said that she knew I would find out eventually. And that is why she didn't tell me the 20th. And he was probably shocked by this. And we got in the car and he immediately had an accident in the car, didn't tell me about it. He just had an accident, didn't say anything. And when I got him back, he then started having accidents every single day at his school for, I think, 2 weeks, just out of the blue. So I felt like this kind of like, visit without him being able to emotionally prepare was having an impact on him. And so I said, if you want time with him, we need to do it in a way that's good for him. And so just let's plan ahead for it. But the only thing Miss Russell's saying is to do with me in terms of trying to schedule these things is always just asking the day before or the day of even sometimes. And so that's what's happened here. She would not communicate with me, would not try to coordinate or co-parent with me, and only gave last minute, requests for time. And so the end result with these, that did not zoom the way I wanted to, but if we look at the splits here, I have the past 90 days, past 80 days, past year, and then the total running time. And they're pretty severe. And this wasn't me just trying to stat pad or anything like that. It wasn't being like, oh, I need to get this weighed heavily in my favor. I was protecting my son in this. I also wasn't going to make an effort to try to get her to do the right thing because honestly, I don't feel that he's really that well cared for with her. So I was waiting for her to show that she could act responsibly, and I have not seen that. There's a reason why I'm the person that filed the motion here too. I had told her that I was going to do it. She could have. There was nothing, I had no legal right to just like withhold this whole time. So she could have legally gotten him at any point, but she didn't because I, I just don't know why. It's very sad for my son that he has an absentee mother, as far as I'm concerned. So that's how things have gone. I want to also testify that, so since starting the 50-50 arrangement, the weeks that my son has been with me, starting in March 2025, he has gone to preschool. He goes 3 days a week instead of the full time, because full time would mean he would there would be attendance counted and stuff, and I wanted flexibility for him. So it's just Mondays, Wednesdays, and Fridays. On Tuesdays and Thursdays, we just spend together because I work from home. And so luckily with my job, I have kind of collect royalties with it almost. I have like a lot of flexibility. So, he and I will just spend the day together, usually going out, on some kind of adventure, things like that. We have a routine and it's good. The whole time he was with Miss Russell, far as I know, unless she has any evidence to prove otherwise, he had never went to any kind of school. And yeah, he, as far as I understand, he had trouble sleeping and just would come back not looking like he had been bathed, looking unkempt, etc. I have, let's see, do I want to go into? Yeah, let me pull this up. With the last, actually, I will save it for cross-examination.
Okay. Are you offering R1 as an exhibit?
I'm sorry, can you repeat the question, Your Honor?
Are you offering R1 as an exhibit?
Yes, and that's yes. Oh, sorry, I thought I had already done that.
No. Ms. Russell, is there any objection to R1?
No.
Okay, R1 is admitted.
Yeah.
Any other exhibits, Mr. Reed?
Let me quickly review. I apologize. Was a bit overwhelmed with how many examples, and so I didn't do the
Okay,
best.
and you've reached 30 minutes of your hour.
Yeah, okay, yeah. All right, so that I think I could end my testimony there.
Okay, so you passed yourself as a witness. We
Yes.
remove the screen share. Or just stop sharing.
Oh, there, I see it. Stop here. Good job.
Okay. All right, Ms. Russell, now is your opportunity to ask any questions you might have of Mr. Reed about his testimony or about the motion he has filed.
Can I just reserve for my narrative?
You can reserve all of your time if you truly don't have any questions about what he has told the court. You think it
I
would
would
be
rather.
more efficient? Okay. To just tell your own side of the story?
Yes, ma'am.
Okay. All right. Then, Mr. Reed, let me ask you, as the movement on this motion, do you have any other witnesses to call or any other evidence to offer?
No, Your Honor.
Okay. All right.
I
Then,
apologize. Sorry. Evidence to offer for specifically my testimony or in general, because I do have cross-examination evidence that I'd like to offer when.
okay. Well, I think if you don't have any other witnesses to call, Ms. Russell will testify, and then you will have an opportunity after she finishes to ask her questions.
Great. I appreciate it.
Okay. All right, Ms. Russell. You can do what Mr. Reed did, and that is testify in the narrative, tell the court about the situation and what you're asking the court to do or not do here.
Sorry. First of all, just because it's kind of eating at me, I would like to show my child's room if possible.
That's fine.
Okay, is it going to mess with you if I walk? Do you want me to turn the camera off while
That's
I walk?
okay. I'll avert my eyes. That's fine.
Okay. Just because it's such a basic thing. That's my daughter's room. This is my son's room that he's had since we've lived here.
Okay.
Just, it exists.
Sure.
My daughter's room exists. Just wanted to scratch that off on my thought list.
Okay.
Sorry, let me get seated.
That's fine.
Okay. I think that you heard him mention that he had just told me no to picking him up and that we needed to have these conversations and I could have legally come to get him and I chose not to. I did not want to put my son in a position where I'm showing up with police officers, and that seemed very traumatic. And that's why I had drafted the writ of habeas corpus. I have an attorney friend who helped me get that all going. It's one of my biggest regrets that I didn't do that a few weeks ago. Whenever I realized that Mr. Reed was not going to easily allow my son to come home. The threat that he mentioned is non-existent. My older two children are happy, healthy. We have award ceremonies to go to today. They are high achieving, healthy, clean, happy children who very much miss their brother. And that's really what I feel I need to say here. I feel like from the beginning of this case, it's been, I don't want to say a game, but it's been a goal of Mr. Reed to swing the time over to his side to get a modification done. And he used something unfortunate that happened here in order to do that, it feels, is what he thinks is happening. I don't know really how to word it to express how much I just want to get my son home. I miss him very much. He has been enrolled in school here. He's registered for the fall, and I have all the legal rights to do so as it stands. And he's just not allowed him to come home in a way that has felt peaceful and safe. So that's really all I have.
Okay. Why don't you tell me a little bit about the situation with your ex and the assault and how all of that has unfolded, and then what your current living situation is.
I'm currently living in the home that I have been in. Whenever that happened, he agreed to that, and for consistency for my girls, he is looking at prison time. His current offer from the prosecutor is 3.5 years. And that has been his offer for the past 4 or 5 hearings. So it's looking like they're going to set for trial because he's denied that. And that's probably what will happen. I'm getting child support from him. And I mean, I thought whenever I originally moved into this home with him, it did not, it was not dangerous. It's felt like kind of a chance for my older children to have things resolved and for Grant to be in a more stable home. And unfortunately, he started struggling with alcohol, and an unfortunate event happened. And I realized that that's not what's going to happen for our lives. But we are now here, and I'm in a stable home. And I just feel like Ty has taken advantage of what happened in order to swing custody over to him. I originally agreed to letting him spend more time with Ty in order to make sure nothing happened that was dangerous for Grant. And since all of that has gotten resolved, he has not allowed him to come home.
Okay. And your ex, remind me his name.
Jeff.
Okay. And he's currently incarcerated?
No, he is out on bail,
Okay.
on bond,
And where is he residing?
his sister's house.
Okay. And are there any orders in place that keep him away from you or your residence?
He's on a tether.
Okay. So a monitor?
Yes.
Okay. All right. And that order of protection, does it extend to the children in the household or just to you?
To the children as well. I'm not sure if that expired after the initial 90 days or
Okay. That was a part of the bond conditions or
yes, ma'am. Yes,
Okay.
ma'am.
Okay. And have you had contact with him since his release?
No.
Okay.
I mean, I have through, to make arrangements for things, but not directly.
Okay. All right. And I guess, so what is the school that you have enrolled?
Birdville ISD.
Okay. Kerrville?
Birdville, Birdville.
Okay. And where is that?
Hurst, Texas, north of, I'm up in Fort Worth because I
Okay.
had the exclusive rights to his residence and everything. And Judge Arth gave me the right to move up here.
Right. Tarrant County or Travis County.
Yes,
And you're
ma'am.
still in Tarrant?
Yes, ma'am. That's where my entire family is. That's where all the cousins are. That's where I'll stay.
Okay.
And that's where my girls have been in school since 2023. And they're very active in their extracurriculars.
Okay. And the actual city that you're living in is what?
Westworth Village, 76114.
Okay. And the home that you showed us the images from, is that, or are you leasing or do you own it?
Leasing.
Okay. And is the lease in your name?
It's technically in both of ours.
Okay. But you're still on the lease.
Yes, ma'am.
Okay. And you're still able to afford the lease?
He paid it through the year.
Okay. All right. And if he gets incarcerated, are you going to be able to continue to pay?
Yes, ma'am.
lease? Okay.
Given I say that with the expectation that things will be back to normal and I'll be getting child support again from Mr. Reed because I've gotten nothing since kind of probably since we started. It's been since before September that I've gotten any child support from him.
Okay.
Which I agreed to because he had the child more, but with going forward would not be workable.
Okay. All right. Anything else that you want me to understand about the home situation, the family dynamics, or any other response to Mr. Reed's motion to modify?
Just that I have extensive family here, support, that we have lots of cousins. We have, I mean, my sister and her daughters are here, my mom, just lots and lots of cousins, lots of family. We lived temporarily with my grandparents after Tyler and I split, and I moved back up here. He's very, very close with my grandparents, his great grandparents, who he has not been able to see. Um, just lots and lots. I mean, if you look at Holly factors, we're doing good on that here.
Okay. All right. Anything else I need to know about your son or this case?
Just that I miss him very much.
Okay.
And that's it.
All right. You pass yourself as a witness.
Yes, ma'am.
Okay. Mr. Reed, this is your opportunity to ask Miss Russell any questions that you may have about her testimony.
Thank you, Your Honor. Okay. Okay, Ms. Russell, do you have any sources of income right now?
Yes.
Can you explain?
I've been doing freelance hand lettering and working for my cousin, her photography.
Miss Russell, would you mind adjusting your camera? I can't really.
Sorry.
There you go. Thank you.
And I have also been in works with working for the City of Westworth Village Police Department. We're waiting for the case to close out all the way so that it doesn't create like a conflict of interest with Jeff's court case. But I'll be hopefully doing dispatch for them once this is all over, because the police department's in our backyard.
Can you confirm that you previously told me that the lease that at the house that you're at was ending in April this year?
I don't recall exactly when it was supposed to end, but we were on month-to-month basis before he paid up through the next. I think now we have 8 months left.
All right, let's see. Okay. Before the incident, were there signs that the incident may happen? Were there problems at the house?
There was one day that was not good that I remember sharing with you, but other than that, things were not terrible.
So there was no consideration to moving out of that house.
There was.
Okay. If you were to move out of that house, where would you move?
Temporarily, probably into my mom's apartment that she has in the back of her property.
Can you confirm that you had told me that he had previously physically assaulted you prior to us being together?
A long time ago.
Was there something that led you to believe that that might not happen again?
Yes, or I wouldn't have put us here.
Okay. Can you acknowledge that you did not tell me when you first moved in back in Woodruff?
I think that we had stayed here a few times and had not yet intended to move in. And I didn't tell you about those times that we stayed here.
Do you think that was the appropriate choice to not tell me?
No, I don't.
Was anyone else present at the house when the incident occurred?
The girls were here.
Did the girls hear the incident?
Yes.
Okay.
That's why I was so thankful that my son was not here that day.
Okay. Can you confirm that over the course, since the initial temporary orders went in place, that there were several missed exchanges or at least delayed exchanges.
When are we talking about?
Talking about through, let's say from 2024 through September 2025. Days in which we were supposed to meet, where I was returning grant to you that you told me the day of that you could not meet.
Yeah, I had lots of car trouble at that point.
I expressed displeasure, I guess I could say, with how late the notice you were giving us multiple times. Is that correct?
Yeah.
Okay. Do you recall ever apologizing?
No,
Okay.
I recall apologizing for my lateness.
Do you recall times that I asked you for updates regarding when to expect you in the interest of our son?
I do recall that. I don't recall not giving that.
Okay. All right. All right, let's see here.
There might have been times where you texted and I called, you called and I texted. I just, at this point, that feels like a very long time ago.
Okay. Your Honor, I would like to offer exhibit respondents exhibit 7.
Okay, you're going to need to display it on the screen so Miss Russell can see it and tell the court whether she has any objection to it or not.
One moment. Okay. Right. Ms. Russell, are you able to see my screen?
Yes.
Okay, the exhibit that I'm showing here is this one. Any objection?
No.
Okay. What are we looking at, Mr. Reed?
This is a text message exchange between us. It was it's not a standard screenshot. There were so many that we have so much text history together that I found an app basically to kind of like make it much easier to read, plus adding all like the timestamps and everything. Just
Okay,
to explain.
R7 is admitted.
Yeah. Okay. Appreciate it. Okay. Let me, Your Honor, let me know if you have any questions about what any of this stuff means. Also, just to preface this, at a certain point, you will see a change in phone number from Ms. Russell. So I guess the first thing, Ms. Russell, can you confirm that this is your old phone number right here?
That's my previous phone number.
Previous phone number. Okay. Okay. All right. Let's see. Okay. So this, what I'm showing here is an text around the exchange that we had in August of 2025. Do you remember this? Looking at this?
I do, and yes, I do.
Okay. Can you acknowledge that when I asked you about how do I describe it? The infection on his lip, that you offered no response?
At that point, I do remember that he had a little red bump kind of right here that had appeared that morning. I didn't think much of it. I thought it was just snot. As you'll note, I said, we need a wipe right before I gave him back to you. We need a wipe. It turns out the next day I got a call from my sister that her kids had impetigo. I didn't know yet. And it turns out that that's what Grant had. That was the first day that we had seen anything on his lip. He actually got it from my mom, who got it from my sister's kids. They hadn't seen each other, that exchange. And it turns out whenever you took him to the doctor, it was impetigo.
Okay. I'd like to offer respondents exhibit 8.
You'll need to display it.
Okay. Yeah. I'm sorry if I'm not getting the protocol here. Do I click it first and then ask?
Yeah, you need to open it up so she can see it.
Okay. And then I ask. Okay. All right. Understood. Sorry about that. Okay.
So R8 was offered, and it's a photograph of the bump on the lip. Miss Russell, do you have any objection to R8?
No.
It's admitted.
Okay. All All right, so I regret taking this picture after he had a shower because it looked much worse beforehand. But this was taken the evening of. And I just want you to confirm that you were saying that this showed up on his lip that morning.
It was not that bad whenever I had him with me. No, it looked to me like, you'll notice he has a little bit of snot on his nose. It looked just like regular allergy irritation. It didn't look like that.
Okay.
An impetigo is a normal childhood thing. My older two never got it, but
Okay. I'd like to offer exhibit respondents exhibit 9.
Any objection to R9?
no.
It's admitted.
Do you recognize this portal, Ms. Russell?
Yes.
This screenshot was taken yesterday, I believe, and it's still showing here because it's not linked with the doctor right here. But do you acknowledge that he had pretty significantly overdue vaccinations the time that he was with you, primarily in your care?
For a couple of them, he was overdue, yes.
Is there any
Which
reason
started when we lived together in Austin, his schedule being off.
Is there a reason why this hepatitis B vaccine was overdue since
I don't
2021?
recall, but I do know that we had missed 1 or 2 appointments. We had scheduling conflicts, and then I think that you had taken him whenever you had him next and got him up to date. Which I looked at as cooperative co-parenting.
Apologize for the language here, but I was frustrated. Your Honor, I'd like to offer R12.
Any objection to R12?
No, ma'am.
It's admitted.
Okay. There are 2 things going on in this one. Let's see. Okay. All right. Specifically, there was. Let's see. Okay. Do you recall missing this week of possession due to the eye issue that was mentioned here?
Yes, I had uveitis.
Okay. And then addressing this text message here. So this is back, this was a year ago. And so do you acknowledge that I was already mentioning things that our son had said to me that early on?
Sorry, I'm just reading. That's not how that happened, but I remember this message now.
Okay. You do explain it here. The main thing I'm asking you is oh, sorry, you already have, never mind. Let's see. Okay. And we've already discussed that. Okay. Do you acknowledge that you gave no response to this text message, this last text message that I sent on the 4th?
It appears as though I didn't.
Okay.
Was this the same week that I still couldn't see? Yes.
Well, you were able to respond to some text messages, but other ones. Okay. All right. I'd like to offer R13, Your Honor.
Okay, is there any objection to R13?
No, ma'am.
It's admitted.
Thank you, Your Honor. Yeah, Ms. Russell, do you recall receiving these texts?
I must have, but not specifically. But yes, it appears as though I did.
Okay. All right. And then these texts were before the incident with Jeff. Is that correct?
Yes.
Okay. Do you acknowledge that you did not respond at all about, requesting having a discussion here?
It appears as though I didn't.
Okay. All right. And following this, the incident happened after this text on the 8th.
It happened on the 13th.
Oh, okay. I apologize. I thought it was the 16th. The 16th. It was the 16th, the day that
The
he got
16th
arrested.
was the day he was arrested, or the
Okay.
day that he was bailed out.
Okay. So it happened on the 13th, and you notified me on the 17th. Is that correct?
I don't recall.
Okay. All right.
I do recall that whenever I told you about it, he was still in jail.
I can confirm. Yeah, so I can confirm that. Wait, what did I just do? No. Okay. Okay. Do you acknowledge that you agreed here that Grant should stay with me and that we should not be exchanging due to safety concerns?
I recall that being my idea.
Yeah.
Just until we knew what was going to happen with him being bonded out and what the conditions were.
Okay. Your Honor, I'd like to offer R14.
Any objection?
No, ma'am.
It's admitted.
Okay.
And Mr. Reed, you've used about 48 minutes of your time. Just
Yeah, these are the last things. Okay. Just I would like to get quick acknowledgement that we had discussed having a conversation, but you did not call during any of these periods. This is going back to before the incident. This was in September last year.
If this was directly before the incident, between his birthday and the incident, it was probably the hardest week of my life. So I don't remember much from that week.
All right. And then let's just shoot ahead here. Okay. I'd like to submit R15, Your Honor.
any objection?
No, ma'am.
It's admitted.
Okay. All right. This was the day of getting it back this past February. So I took this picture of our son and sent it to you that night. Had you noticed this eczema outbreak on his face, Mr. Russell?
This is when? Sorry.
Last time you had him, February 24th of this year.
I had noticed he had been breaking out a little bit.
Did you put any kind of ointment or anything on him?
Yes.
Okay.
So struggled with eczema on and off his entire life.
Okay. Let's see. Can you acknowledge that then starting here in March, at the end of March, I requested a handful of times and you told me multiple times that I would be receiving a call from you, but you never actually called. So we have this instance on the 31st. I replied to say, tell you when it's good for me. Then we have on the 7th. You telling me you'd call again. Give you time. And there was no call on the 8th. And no correspondence until this on the 20th.
It appears that's correct.
Okay. I okay, Ms. Russell, do you have any concerns about the health, safety, security of our son while he's with me?
No, other than the emotional needs of being with his mother.
Do you have any questions about my dedication to our son?
No.
Okay.
He is your one child. I would expect that.
Um, I that is all from you, Your Honor.
Okay.
My question.
You can stop the screen share. Okay. Anything else, Ms. Russell, to tell the court?
I'd just like to acknowledge that at every turn, I've been trying to keep him informed of things. You know, I never want to keep anything from him or keep him in the dark. And I feel like at every turn that has kind of been used. I mean, I didn't have to keep him updated on every aspect of Jeff's case. I've just been trying to do the right thing to make sure the father of my child has been well informed.
Okay. All right, Mr. Reed, you can do a brief closing, basically sum up what you are asking the court to do and what evidence you think supports that request.
Okay. Yeah. I meant to type this one out. No script, so I'm gonna have to wing this one. Okay. Are there any clarifications that I can make to her testimony? I forgot to mention anything regarding child support, and she mentioned one thing that I'd like to clarify, if possible.
You can add to or clarify that testimony. That's fine.
Okay. All right. Yes. And so to reiterate here, I am asking the court. The relief I'm requesting is a modification of our current temporary orders to change the current possession arrangement. Where did I put my notes? I'm so sorry. Hold on. The having me named as sole managing conservator and removing any child support obligation. I put some conditions in there because I wasn't sure what was realistic and feasible, and I didn't, want no relief to be granted because I overreached. However, I don't feel that I'm overreaching with these. In terms of possession, based on how many possessions have been missed over the past 2.5 years, I think a single weekend per month is most realistic for Ms. Russell. Plus, for my child, he's spent so much time with me and he's used to this. And it will help him to know when I can give him a 2-week notice each time. Hey, you're getting this weekend with mommy and stuff. Whereas anything more, I feel like we would be going back to what he's kind of used to. We're supposed to meet today, but I'm not sure yet because I haven't heard from mommy yet, which became such a regular thing that he just stopped asking entirely. Regarding the child support obligation, when we agreed to the 50-50 arrangement, that came with her agreeing to cut the child support payments in half, which I did. Then as some weeks were missed, entire weeks at a time, I started cutting those weeks out because I was sending our son to school. And so she would only get a quarter on those. That is what happened in September of last year, where the last time she received any support from me was on September 21st, where I paid her a quarter because she only had 1 week with him. Since then, he's essentially been in my care full time, and he's been going to school this whole time, and it didn't really make any sense to be sending her any support when she wasn't in possession of the child. So I'm not sure what else to add here. I since the start of us separating, my goal in life is to provide for my child, and it's been a bit of a nightmare the past 2.5 years. Like what's going through. I hate that things are in the state that they are, but I have to be realistic about what his mother's capabilities are, and I don't think she is anywhere near fit to be the primary conservator for my son. On the topic of school, I have him registered at a charter school, and we are moving. Well, technically, the lease starts tomorrow, and we are zoned to go to one of the better elementary schools in AISD, and it's within walking distance. I haven't made a decision on that, but I can't because I don't have the orders in my name. But it is coming up soon. He's 5 years old, so he'll be starting kindergarten this fall. So there is some urgency here. I'm not sure I have anything else to add there. I just hope that my request is granted. Thank you, Your Honor.
Can I add
Okay.
something, Your Honor?
You get to make your own closing remarks.
Oh, okay.
I think he's done, so you may proceed.
I just wanted to add that originally, whenever we were in talks of how things were going to go forward, it was discussed between Tyler and I that whenever Grant started kindergarten, he might move here. And even Judge Arth had said, there's no reason y'all couldn't do 50-50 if you were up there with her. As a father, I suggest getting up there. And we had discussed that. And that's why I originally felt comfortable making the 50-50 arrangement that I had made with Ty, because it was pretty common understanding that the closer we got to kindergarten, he would be making a move up here. The only thing keeping him there is his mother, who lives next door to him.
Yeah, can I object to that?
What's the basis of the objection?
It's what's the name of it? It's speculation on my intentions.
Okay. You may continue, Ms. Russell.
The only family that he has there is his mother, and that is the only reason he's ever given me as to why he wouldn't move up here like we had originally been tossing around the idea of. And it just seems as though now that he thinks he has the grounds to, get Grant primary with him, that's no longer in discussion, which makes me wonder if that was ever really what he wanted to happen so that Grant could have both parents around.
Okay. All right. Anything else I need to understand about the situation, Ms. Russell?
No, ma'am.
Okay. Anything else, Mr. Reed?
I'm not sure if you need clarification on that. I will always make decisions based on what is best for my child. I have, based on the network that we have here, family, just location in general, I believe that it is better for him to grow up here in Austin than up there. There are too many people that we would essentially stop seeing and stuff like that. So I don't think there's anything that it's not a selfish decision on my part. That's it.
Okay. All right. Let me just look at. Okay, after having heard the evidence this morning that has been presented by both parties, I will deny the motion to modify. And let me just say, going forward, the order that is in place, and that's the temporary orders entered by Judge Arth back in October of 2023, those govern what you do, where the child is to be, and only agreements that are in writing and filed with the court can modify these orders. I haven't heard or seen anything to that effect. I need to just encourage you going forward to be an example to your son, how you treat each other, how you interact with each other, with each other is an example to him. You're his primary models for how an adult relationship should be conducted. So it does concern me that the orders have basically been ignored on both sides. And I will just say the schedule that you have is the schedule that you have, and you both need to start abiding by it. It does look like to me that there has been withholding of the child going on, and I don't like to see that. In these cases, the primary parent has to be able to support and nurture the relationship of the child with the other parent. And just so it's clear for the record, I do find that there has not been a material and substantial change such that the modification is in all things denied. Are there any questions about the court's rulings?
So I can just go get my son?
Is this a date that you are supposed to have him under the
I think
October order?
today is actually maybe a standard possession order weekend.
Okay.
So Sunday would be the day that we do an exchange back.
Let me look at the calendar. Is this the third weekend? Okay, just give me a moment here. I only have so many screens open at one time. Yes, this is the third weekend. So this would be the standard possession order. This would be Friday afternoon would be the starting of Mr. Reed's time. So the exchange would happen. I do have the order over here,
We're
but
in Waco on Sundays.
and Waco on Sunday. Yes, y'all need to get back doing what you've been ordered to do. Okay.
Yes, ma'am.
And any other questions, Mr. Reed?
Yes, Your Honor. I don't believe Ms. Russell will be able to afford mediation. So I'm wondering if it's possible that requirement can be waived prior to heading to final trial. I doubt how to go. I guess now the timeline doesn't matter as much, so I'll just submit a motion for it. Apologies.
Okay, so our local rules do require mediation, and what you have in place is a temporary order. You don't have a final order in place. So what you've actually asked the court, Mr. Reed, is something that is not on file, that is not set for a hearing today. So there are some low cost or no cost mediators available in town. You can try the Dispute Resolution Center. You can also try the Austin Bar Association has a list of low cost and mediators that will do a pro bono mediation. So those are some resources that are available.
So the deadline, I mean, does the deadline for the summer possession schedule? No, so it's already coming past. Does that mean that it just defaults to what I can't remember what it is. but
I think
they were
there
saying
are default dates included in the order. Um,
okay.
okay. All right. Seeing nothing else, yeah, if you didn't designate by the April 1 and April 15 deadlines, I do think it has other provisions for when parties fail to do that.
We
Okay.
can talk.
Yes. Well, I encourage you to do that and just look at the order and do your best